Hi everyone, I'm Mark Trenner. If you're an inventor or a startup founder, you've probably heard that a provisional patent application is the entry point to protecting your idea. But there's a lot of noise out there about what you actually need to file. Today, I want to pull back the curtain on 3 things that my clients always ask me about: drawings, secrecy, and what happens when your invention evolves. First, let's talk about the drawings. A lot of inventors freeze up because they think they need professional blueprints before they can even give me a call. They don't. I once had a client come to me with a brilliant mechanical tool, but all he had were photos of a prototype that he actually had just made out of PVC pipe and duct tape. But for a provisional, that's actually fine. We used his photos to secure his filing date immediately. Now, when we go to file the full utility application, be assured my flat fee includes professional draftsman drawings. We're going to have that patent application ready to go for filing at the patent office. But to get your foot in the door with that provisional application, your sketches or photos are often going to be plenty. All right, second, secrecy. People worry that filing a patent means telling the whole world their secret sauce. It doesn't. Your provisional application stays completely confidential for 12 months. Even after we file the full application, it stays under wraps at the patent office for another 6 months. That's 18 months of total stealth mode. I worked with a startup recently that was terrified a competitor would see their filing and pivot to copy them. I had to reassure them, you have a full 1.5 years of protection before the public even knows you exist. Now that's a massive competitive advantage. And if it's not enough, you may be able to file a non-publication request when you go to file your full utility application. That will keep your invention secret until it issues as a patent. All right, finally, third, let's talk about what to do if you change the design. After all, innovation isn't static. I had an inventor who filed a provisional application for a wearable tech piece. You know, the glasses where you can actually, it displays out in front of you just like what's on your phone. But 3 months later, he realized a different sensor worked much better. Instead of starting all over, we just filed a second provisional application for the update. I call it a supplemental provisional application. When it came time for the full application, we just combined the two. This gave him 2 different priority dates. One covering the original invention, and another filing date covering the upgrade. You don't have to be perfect on day 1, you just have to be protected. Or filing for a patent doesn't have to be an all or nothing hurdle. It's a strategy, and that's what I do all day long for my clients. If you're wondering which path is right for your specific invention, reach out to me directly. You won't be passed off to a junior associate or a patent agent. Instead, you'll be working directly with me to protect your innovation. Thanks for watching.